Hello everyone. From today onwards, I just have to finish a book that is a Civil Procedure with Limitation Act 1963 by C.K. Takwani, and the book contains almost 750 pages. So let's see how much time does it take to finish up this book. Can you see the thickness of this book? I have already read up till yet, like half of the portion I have already finished up, but now still I have to start from the page number 1. Basically, after finishing up this book, I will get a rough idea like what the content of what are the content in this book, and then analyze the further things. Then I am going to analyze the further things like or how much beneficial it was for me. I don't have to do a lot of thing or a kind of a twisted thing. I just have to read this book, that's it. And it depends upon my mind, like what the portion that I have that got stuck in my mind, that's it. I don't know what you are going to learn from this video, because I don't think so if I'm reading something and you are just listening it up that you will get anything. This is just for the my soul satisfaction that I have just finished up a book and I have that recording, that's it. So this is I will try to read being as an being vocally, but I can also read in a silent way, so it would be the mixture of both. Chapter number 1, Introduction. Procedural law. Law can be divided into two groups: substantive law and adjective or procedural law. Whereas substantive law determines rights and liability of the parties, adjective or procedural law prescribes the practice procedure and machinery for the enforcement of those rights and liabilities. In Halsbury Laws of England, it has been stated that there is at the outset a vital and essential distinction between substantive law and procedural law. The function of substantive law is to define, create, or confer substantive legal rights or legal status, or to impose and define the nature and extent of legal duties. The function of procedural law is to provide the machinery or the manner in which the legal rights or status and legal duties may be enforced or recognized by a court of law or other recognized or properly constituted tribunal. Procedural laws prescribe procedure for the enforcement of rights and liabilities. The efficacy of substantive laws to a large extent depends upon the quality of procedural law. Unless the procedure is simple, expeditious, and inexpensive, substantive laws, however good, are bound to fail in achieving their object and reaching the goal. Procedural law is thus an adjunct or an accessory to substantive law. The two branches are complementary to each other and interdependent, and the interplay between them often conceal what is substantive law and what is procedural law. It is procedural law which puts life into substantive law by providing a remedy and implements the well-known maxim ubi jus ibi remedium. The Indian Contract Act, the Transfer of Property Act, the Industrial Dispute Act, the Indian Penal Code are instances of substantive law, while the Indian Evidence Act, the Limitation Act, the Code of Civil Procedure, the Code of Criminal Procedure are instances of procedural law. Let me repeat the same para once again. The Indian Contract Act, the Transfer of Property Act, the Industrial Dispute Act, the Indian Penal Code are instances of substantive law, while the Evidence Act, Limitation Act, and the Code of Procedure The Code of Civil Procedure and the Code of Criminal Procedure are instances of procedural law. The Code of Civil Procedure is an adjective or procedural law. It neither creates nor take any right. It is intended to regulate the procedure to be followed by civil courts. History of the code. Before 1859, before 1859, okay, there was, after the 1857, after the revolution. Before 1859, there was no uniform code of civil procedure. There were different systems of civil procedure in different part of the country. The first uniform code of civil procedure was enacted in 1859, but that code was also not made applicable to the Supreme Courts in the Presidency town and to the Presidency small causes courts. Some amendments were made therein, and the code was applied to the whole of British India, but there were many defects in it, and therefore a new code was enacted in 1859, then 1877. Again, another code was enacted in 1877, then 1882, after 5 years. So 1859, then 1859, then 1859, then 1877, then 1882, which was also amended from time to time. In 1908, the present Code of Civil Procedure was enacted. It was amended by two important amendments, Act of 1951 and 1956. On the whole, the code worked satisfactorily, though there were some defects in it. The Law Commission, in its various reports, made many recommendations, and after carefully considering them, the government decided to bring forward the bill for the amendment of the Code of Civil Procedure 1908, keeping in view inter alia the following consideration. A litigant should get a fair trial in accordance with the accepted principles of natural justice. Every effort should be made to expedite the disposal of civil suits and proceedings so that justice may not be delayed. Third, the procedure should not be complicated and should, to the utmost extent possible, ensure a fair deal to the poorer sections of the community who do not have the means to engage a pleader to defend their cases. Some of the important changes made by the Amendment Act 1976 are as under: the doctrine of res judicata is being made more effective. Second, power to transfer proceeding from one high court to another is given to the Supreme Court. Third, freedom from attachment of a portion of salary to all salaried employees is granted. Fourth, provision of giving notice under Section 80 before the institution of a suit against the government or a public officer is made less stringent. Fifth, restrictions are imposed on the right of appeal and revision. Sixth, the provision are being made to ensure that written statement and document were filled without delay. 7. New order, that is order number 32A, has been inserted to provide a special procedure in litigation concerning the affairs of a family. 8. The practice to pass preliminary and final decree in certain suits is abolished. 9. Scope of summary trials is substantially widened. 10. Important changes have been made to provide relief to poorer section of the community. The amendments made in 1976 were not found sufficient with a view to dispose of civil cases expeditiously. Justice Malimat Committee was appointed by the government. In pursuance of recommendation of the committee, the code was amended by the Amendment of 1999 and 202. Important amendments made by Act of 1999 and 202 may be summarized thus: in several matters such as issuing of summons, filing of written statement, amendment of pleading, production of document, examination of witness, pronouncement of judgments, preparation of decree, etc., a time limit is prescribed. Second, a new provision for settlement of disputes outside the court has been introduced. 3. Number of adjournments have been restricted. 4. A provision for recording of evidence by the court commissioner has been made. 5th. Endless arguments are sought to be shortened by empowering the court to fix a time limit for oral argument and by permitting written arguments to be placed on record by the parties. Oh God. 6th. A provision is made for filing of appeal in the court which passed the decree. 7. Institution of appeal against the judgment is allowed where the decree is not drawn up. 8. Scope of first appeal, second appeal, letters, patent appeal and revision has been curtailed. Commencement. The Code of Civil Procedure 1908 came into force with effect from 1st January 1909, while the Amendment Act 104 of 1976 came into the force with effect from 1st January 1977. It may be stated that the Code of Civil Procedure Amendment Bill 1974 was passed by Parliament on 23rd August 1976. It received the assent of the President on 9 September 1976. It became Act of 104 of 1976 and came into force from 1st February 1977 except Section 12, 13 and 50. Section 12 and 50 came into force on 1st May 1977 and Section 13 came into force on 1st July 1977. The Code of Civil Procedure Amendment Act 1999 received the assent of the President on 30 December 1999 and came into the force from 1st July 2002. The Code of Civil Procedure Amendment Act 2002 received the assent of the President on 23rd May 2002 and came into force on 1st July 2002. Consolidation and codification. The preamble of the code states that the object of the code is to consolidate and amend the laws relating to the procedure of courts of civil judicature. To consolidate means to collect all the laws relating to a particular subject and to bring it down to date in order that it may form a useful code applicable to the circumstances existing at the time when the consolidating act is enacted. The very object of codifying a particular branch of law is that on any point specifically dealt with, the law should thenceforth be ascertained from the language used in that enactment and not from the preceding act. The Code of Civil Procedure is a consolidated code as to, I don't have to just use the term it is a filler. I have to avoid using this I can't use this term. The Code of Civil Procedure is a consolidated code as to procedure to be followed by civil courts. We observe in Premlala Nahata vs. Chandani Prasad Sikaria, the code consolidates and amends the laws relating to the procedure of the courts of civil judicature. No doubt it is also deals with the certain substantive rights, but its essential object is to consolidate the law relating to the civil procedure, extend and applicability. The extent and applicability extent and applicability. The code extends to the whole of India. Except the Nagaland and the tribal areas. It also extends to the Amindivi Islands and the East Godavari and Visakhapatnam Agency in the state of Andhra Pradesh and the Union Territory of Lakshadweep. By the Amendment Act of 1976, the application of the provision of the code have been extended to scheduled areas also. It has, however, been held that courts in such shall be guided by spirit of the code and would not be bound by the letter of CPC. Letter of CPC. Letter of CPC. Object of the code. The object of the code is to consolidate and amend the laws relating to the procedure of courts of civil judicature. It is a consolidated code collecting all the laws relating to the procedure to be adopted by civil courts. It is designed to facilitate justice and further its ends and is not a penal enactment for punishment and penalties, not a thing designed to trip up people. Too technical or construction of sections which leaves no room for reasonable elasticity of interpretation should therefore be guarded against, provided that justice is done to both the sides. The provision of the code therefore should be construed why I'm using construed liberally, and technical objections should not be allowed to affect substantial justice. A hyper-technical view should be avoided by the court. The provision of the code have evolved as a matter of long years of experience emanating out of the common law of England. As the Supreme Court stated, a procedural law is always in aid of justice, not in contradiction or to defect the very object which is sought to be achieved. A procedural law is always subservient to the substantive law. Nothing can be given by a procedural law what is not sought to be given by a substantive law, and nothing can be taken away by the procedural law what is given by the substantive law. I should read it once again. The procedural law is always subservient to the substantive law. The procedural law is always subservient to the substantive law. Nothing can be given by a procedural law what is not sought to be given by a substantive law, and nothing can be taken away by the procedural law what is given by the substantive law. Scope code not exhaustive. The code is exhaustive on matters specifically dealt with by it. However, it is not exhaustive on the points not specifically dealt with therein. The legislature is incapable of contemplating all the possible circumstances which may arise in future litigation and consequently for providing procedure for them. With regard to those matters, the court has inherent power to act according to the principle of justice, equity, and good conscience. The code specifically provides that nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary for the ends of justice or to prevent abuse of the process of court interpretation. Those substantive laws are very important. Value and importance of procedural laws cannot be underestimated, but the procedural law must be regarded as such. The function of adjective law is to facilitate justice and further its end. The rules of procedure are intended to be a handmaid to the administration of the justice, and they must therefore be construed liberally and in such manner as to render the enforcement of substantive rights effective. A hyper-technical view should not be adopted by the court in interpreting procedural laws. A party cannot be refused just relief merely because of some mistake, negligence, inadvertence, or even infraction of the rules of procedure. Rules of pleadings are intended as aids for a fair trial and for reaching a just decision. An action at law should not be equated to a game of chess. Provisions of law are not mere formulae to be observed as rituals. Beneath the words of a provision of law, generally speaking, there lies a juristic principle. It is the duty of the court to ascertain that principle and implement it. Our laws of procedure are based on the principle that as far as possible, no proceeding in a court of law should be allowed to defeat on mere technicalities. The provisions of the Code of Civil Procedure therefore must be interpreted in a manner so as to subvert and advance the cause of justice rather than to defeat it. The principle underlying interpretation of procedural laws has been succinctly laid down by the Supreme Court in the case of State of Punjab versus Sambhal Murari, wherein, speaking for the court, Krishna Iyer, Justice, observed, "We must always remember the procedural law is not to be a tyrant but a servant, not an obstruction but an aid to justice. It has been wisely observed that procedural prescriptions are the handmaid and not the mistress, a lubricant, not a resistance in the administration of justice, where the non-compliance, though procedural, will thwart fair hearing or prejudice doing of justice to the parties. The rule is mandatory, but grammar apart, if the breach can be corrected without injury to a just disposal of the case, we should not enthrone a regulatory requirement into a dominant desideratum. After all, courts are to do justice, not to break this end product of technicalities. Scheme of the code. The code can be divided into two parts. The body of the code containing 158 sections and the first schedule containing 51 orders and rules. The section deal with provision of the substantive nature and laying down the general principle of jurisdiction, while the first schedule relates to the procedure and the manner and mode in which the jurisdiction may be exercised. The body of the code containing sections is fundamental and cannot be amended except by the legislature. The first schedule of the code containing orders and rules, on the other hand, can be amended by the Honorable High Court. Looking to the scheme of the code as whole, it becomes abundantly clear that the amendments made by the High Courts in the rules contained in the first schedule also become part of the code for all purposes as if enacted in the code. The sections and the rules therefore must be read together and harmoniously construed. But if the rules are inconsistent with the section, the latter will prevail. Retrospective operation. It is a well-settled principle of interpretation of statutes that procedural laws are always retrospective in operation unless there are good reasons to the contrary. Their provision will apply to the proceeding already commenced at the time of their enactment. The reason is that no one can have a vested right in form of procedure. The Code of Civil Procedure is not retrospective in operation. I should read this para once more. It is a well-settled principle of interpretation of statutes that procedural laws are always retrospective in operation unless there are good reasons to the contrary. Their provisions will apply to proceedings already commenced at the time of their enactment. The reason is that no one can have a vested right in forms of procedure. The Code of Civil Procedure is not retrospective in operation. Code at a glance. Sorry for the inconvenience. Next topic is code at a glance. The substantive part of the Code of Civil Procedure contains 158 sections. The first schedule comprises 51 orders and rules providing procedure. Appendices contain model forms of pleadings, processes, decrees, appeals, execution proceedings, etc. Section 1 to 8 are the preliminary in nature. Section 1 provides for commencement and applicability of the code. Section 2 is a definition clause and a sort of statutory dictionary of important terms used in the body of the code. Section 3 to 8 deals with the constitution of different types of courts and their jurisdiction. Part 1, that is section 9, that starts from section 9 to section 35b, and order 1 to 20 of the first schedule deal with suits. Section 9 enacts that a civil court has jurisdiction to try all suits of a civil nature unless they are barred expressly or impliedly, whereas section 10 provides for stay of suits, that is res sub judice. Section 11 deals with a well-known doctrine of res judicata Section 13 and 14 relate to foreign judgment. Section 15 to 21A regulate the place of suing. They lay down rules as to jurisdiction of courts and objections as to jurisdiction. Sections 22 to 25 make provisions for transparent withdrawal of suits, appeals, and other proceedings from one court to another. Orders 1 to 4 deal with institution and frame of suits, parties to suit, and recognize agents and pleaders. Order 1 to 4 deal with instruction and frame of suits, parties to suit, and recognize agent and pleaders. Order 5 contain provision as to issue and service of summons. Order 6 deal with proceedings. Order 7 and 8 relate to plaint, written statement, set-offs, and counterclaim. Order 9 requires the parties to the suit to appear before the court and enumerates consequences of non-appearance. It also provides the remedy for setting aside an order of dismissal of suit of a plaint and of setting aside an ex parte decree against an order against a defendant. Order 10 enjoins the court to examine parties with a view to ascertaining matters in controversy in the suit. Order 11 to 13 deal with discovery, inspection, and production of documents and also admission by parties. Order 14 require the court to frame issues. And Order 15 enable the court to pronounce judgment at the first hearing in certain cases. Orders 16 to 18 contain provision for summoning, attendance, and examination of witnesses and adjournments. Order 19 empower the court to make an order or to prove facts on the basis of an affidavit of a party. Sections 75 to 78, that is Part 3, and Order 26 make provision as to issue of commissions. Section 94 and 95, that is Part 6, and Order 38 provides for arrest of a defendant and attachment before judgment. Order 39 lays down the procedure for issuing temporary injunction and passing interlocutory orders. Order 40 deals with the appointment of receivers. Order 25 provide for security for costs. Order 23 deal with withdrawal and Order 23 deals with the withdrawal and compromise of suits. Order 22 declares effect of death, marriage, or insolvency of a party to the suit after the hearing is over. The court pronounces a judgment. Section 33 and Order 20 deal with the judgment and decrees. Section 34 make provision for interest. Section 35, 35A, 35B, and Order 28 deal with costs. Part 4 and 5, Sections 79 to 93 and Order 27 to 37 lay down procedure for suits in special cases such as suits by or against government or public officers. Section 79 to 82 and Order 27 suits by or against aliens, foreign rulers, ambassador, and envoys. Section 83 to 87B suits by or against soldiers, sailor, and airmen. Soldiers, sailors, and airmen. Order 28 suits by or against corporations. Order 29 suits by or against partnership firms. Order 30 suits by or against trustees, executors, and administrators. Order 31 suits by or against minors, lunatics, and persons of unsound mind. Order 32 suits relating to family matters. Order 32A suits by indigent persons, paupers. Order 33 suits relating to mortgages. Order 34 interpleader suits. Section 88 and Order 35 friendly suits. Section 90 and Order 36 summary suits. Summary suits. Order 37 suits relating to public nuisance. Section 91 and suits relating to public trust. Section 92 Section 89 as interest from 1st July 2002 provides for settlement of disputes out of court through arbitration, conciliation, mediation and lok adalats. Part 7 and 8, sections 96 to 115 and order 41 to 47 contain detailed provision for appeals, reference, review and revision. Section 196 to 99A and order 41 deal with first appeals. Section 100 to 103 and order 42 discuss law relating to second appeals. Section 104 to 108 and order 243 contain provision as to appeals from orders. Section 109, 112 and order 45 provide for appeals to the Supreme Court. Order 44 enacts special law concerning appeals by indigent persons, paupers. Section 113 and Order 46 pertain to references to be made to a high court by a subordinate court when a question of constitutional validity of an act arises. Section 114 and Order 47 permit review of judgments in certain circumstances. Section 115 confers revisional jurisdiction on high courts over subordinate courts. Part 4, Section 36 to 74 and Order 21 cover execution proceeding. The principle governing execution and decrees and orders are dealt with. Section 36 to 74 substantive law and Order 21 procedural law. Order 21 is the longest order covering 106 rules. Part 10, Section 121 to 131 enable High Court to frame rules for regulating their own procedure and the procedure of civil courts subject to their superintendence. Part 11, Section 132 to 158 relates to miscellaneous proceeding. Explanation to Section 141 as added by the Amendment Act of 1976 clarify that the expression proceedings would not include proceedings under Article 226 of the Constitution. Section 144 embodies the doctrine of restitution and deals with the power of the court to grant relief of restitution in case a decree is set aside or modified by a superior court. Section 148A as inserted by the Code of Civil Procedure Amendment Act 1976 is an important provision which permit a person to lodge a caveat in a suit or proceeding instituted or about to be instituted against him. It is the duty of the court to issue notice and afford an opportunity of hearing to a caveator to appear and oppose interim relief sought by an applicant. Section 148 to 153A confer inherent powers in every civil code. Section 148 enable a court to enlarge time fixed or guaranteed by it for doing any act. Section 149 authorizes a court to permit a party to make up deficiency of court fees on plaint, memorandum of appeal, etc. Section 151 is a salutary provision. It saves inherent powers in every court to secure the end of justice and also to prevent the abuse of process of the court. Sections 152 to 153A empower a court to amend judgments, decrees, orders, and other records arising from accidental slip or omission. Section 153B, as added by the Amendment Act of 1976, expressly declares that the place of trial shall be open to the public. The proviso, however, empowers the presiding judge, if he thinks fit, to order that the general public or any particular person shall not have access to the court. Now we have successfully completed the chapter number 1. Now we are on chapter number 2, that is definition. And up till yet we have read 15 pages. Not 15, 14 pages. Yeah. It took almost half an hour to read 14 pages. How many pages are there in chapter number 2? almost 105 pages are there in second chapter. We will continue this in our next part.